The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act for the purpose of making a state a two-way sanctuary state. But the Trump administration has once again delayed the case for even more time to consider how they want to handle this issue. So let's break down what is happening. Now, before we jump into this video, if you guys want to support the channel for free, please consider subscribing to the channel. That, of course, helps the channel to grow. We've reached over 800,000 subscribers, which is absolutely amazing. Thank you guys so much for all of your support. And then also just drop a positive comment down below, because that helps to tell the algorithm that you appreciate this type of two-way content, and it should share it to more people. In this video, we're going to be talking about a significant Second Amendment protection case, which is once again back in front of the Supreme Court. This is a case dealing with a state's Second Amendment Preservation Act. We have discussed this case before because recently the Supreme Court issued an order denying a stay which would have protected Missouri's Second Amendment Preservation Act, also known as their SAPA law. After that denial order in this case, the case was sent back down to the 8th Circuit, who recently issued their decision in the case. The 8th Circuit sided with the Biden administration and decided that the Missouri SAPA law was in fact invalid in its entirety. The 8th Circuit believed that the law invalidated federal laws in violation of the Supremacy Clause. And now as a result, Missouri has now filed their official petition to the Supreme Court on the final merits, and they're asking for the Supreme Court to step in and strike down what the lower court said. The Supreme Court will now consider whether they will grant review to a state's Second Amendment sanctuary law. However, the Trump administration has once again decided to delay and punt this issue and punt the case to determine how they want to handle this and proceed forward potentially in a pro-two-way way. Now, for those not familiar, back in 2021, Missouri passed a law called the Second Amendment Preservation Act, also known as the SAPA law. The law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that violate the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those types of laws. The law also created a civil remedy where anyone can sue a Missouri official if they help to enforce a federal law that violates the Second Amendment. This Missouri law is similar in nature to the Texas abortion law, also known as the SB 8 law, and it plays directly into what the Supreme Court recently said in a decision called the Whole Women's Health case. With the Texas and Missouri laws and how they're structured, you can't get an umbrella injunction against the state or the attorney general since they're not actually the ones enforcing the law. Instead, you would need to get an injunction against every single private individual who files a civil suit. In this Missouri case, the District Court on review ruled in favor of the Biden administration, striking down the Missouri Preservation Act in its entirety. Now, in response, the state of Missouri then appealed to the 8th Circuit. And at that time, they asked for the 8th Circuit to stay what the lower court said and essentially put a hold on what they issued in favor of the Biden administration. However, the 8th Circuit denied that stay request, and so that led Missouri for the first time to go to the Supreme Court on an emergency application and ask for the Supreme Court to step in and grant a stay. On review, the Supreme Court issued an 8-1 order denying that stay. Only Justice Thomas was in favor of granting that emergency stay in favor of the state of Missouri and their whole SAPA law and keeping it in place while this appeal was taking place. However, then after the Supreme Court's denial in that 8-1 order, the case was sent back down to the 8th Circuit, who held expedited arguments in this case and has now issued its decision. The 8th Circuit ultimately ruled in favor of the Biden administration, striking down the SAPA law in its entirety. But now Missouri has filed their writ of cert to the Supreme Court, and once again, they're asking for the Supreme Court to step in and strike down what the lower court said and allow Missouri to keep in place the SAPA law. In the petition, Missouri presents three main questions for the Supreme Court to finally answer. First, can federal courts second-guess a state's reason for exercising 10th Amendment authority? Second, does the Constitution prohibit states from exercising 10th Amendment authority when motivated by a concern that a federal statute is unconstitutional? And third, is a state official a proper defendant under Ex parte Young simply because the official is regulated by a statute, or does the official also need to possess authority to enforce the law? Missouri goes on to say in their petition that before this case, it appears no federal court had ever blocked a state from exercising 10th Amendment authority, simply because of the reason that the state expressed for exercising that authority. The 8th Circuit did that here, striking down a state law solely because the act said that the legislator believes a certain federal statute are unconstitutional. The 8th Circuit's holding creates multiple circuit splits and is as wrong as it is unprecedented. It declared a Missouri law unconstitutional solely because of the law's legislative findings. Specifically, the legislator's opinion that some federal statutes are unconstitutional. The court took no issue with what Missouri law does, only with what the legislative findings say. Indeed, the court agreed that a law with the same effect but different findings would be permissible. As the court put it, Missouri may lawfully withhold its assistance from federal law enforcement if it picks a different reason, such as withholding resources as a matter of policy rather than as a matter of constitutional interpretation. Now, one of the main things that Missouri is pointing out in their petition and what they're saying that the 8th Circuit essentially did is the 8th Circuit said that the structure and potential operation of this law in Missouri is valid, but ultimately they struck it down because of its underlying Second Amendment purpose. Missouri argues that the 8th Circuit was wrong to do that this law is clearly valid. Even the 8th Circuit recognized that this structure is valid, but they just didn't like that it was aimed and its whole goal was to protect the Second Amendment. Missouri also argues that the 8th Circuit went against clear precedent and found that a state official could be sued because the court believed that the state official there played a role in enforcement simply by complying with the state law. Essentially, the court found that an officer or agent in Missouri complying with the statute and taking no action, so essentially non-action, was actual enforcement, and therefore they could be sued and an injunction could be issued against them. Now, this law was originally opposed by the Biden administration, but now the Trump administration is in control of the government and they have control of this case and how this litigation proceeds forward. Originally, the federal government was set to file their reply brief to the Supreme Court on February 26th, but they have now received multiple extensions. The Trump administration has received multiple extensions in this case to essentially determine how they want to handle this issue. Now, once again, days before needing to file their response brief to this petition, the Trump administration has asked and has essentially received another extension. So the Supreme Court has given the Trump administration until June 10th to file the response brief to this petition and outline how they want to proceed forward on this issue. One of the important aspects of this case is that the petition was filed by the state of Missouri. So unlike prior Supreme Court petitions filed by the administration, they don't have the option to simply just to drop this case. Instead, they're going to have to respond to the petition eventually and give some sort of answer. I have no doubt that the 2A task force is taking a long look at this case and coming up with a way to be pro-2A, maybe a pro-2A approach in this issue, especially because the current U.S. Solicitor General was prior the attorney for the state of Missouri, representing their interest in trying to protect the Missouri SAPA law, and he was litigating that against the Biden administration. So now he's in control of the office and is one of the main ones overseeing all these lawsuits, and this is one of those ones that he essentially had to recuse himself from, so he can't litigate it himself, but of course he has oversight over this, and so he's going to make sure his office is aligning with what he believes is proper, and essentially to protect the Missouri SAPA law. Now, at this point, the Supreme Court has given the Trump administration multiple extensions based on the same reason. So at some point, the bill is going to come due and the Trump administration is going to have to answer this case. However, the general feeling from the Supreme Court may be that they don't want any more high-profile cases. Maybe they're probably trying to avoid this, and maybe they're just fine right now with the Trump administration kicking the can down the road, and so they're going to keep giving them even more extensions. Currently, we're all waiting to see what the Supreme Court does with the Snope rifle ban case and the Ocean State Tactical magazine ban case. And so the clock is also ticking for those as well. The term is going to end soon. And so we're all waiting to see, how are some of these very high profile cases going to develop. This Missouri SAPA case, of course, is not going to be addressed at all this term. Neither will the Snope rifle ban or magazine ban. But a lot of movement can be made, especially in the rifle ban and magazine ban. We want those granted this term, and we definitely don't want them denied. So there's some weird things going on at the Supreme Court right now. A lot of potential delays and maybe kicking the can down the road. So we're going to wait to see how this develops. But the Trump administration, once again, maybe their strategy right now is to keep this one in a holding pattern for a while so they don't have to step in this controversial issue. So that's what's going on with the SAPA law in the Supreme Court. As we get more information, as things develop, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.